Welcome everyone to the presentation of the 2020 SAIS International Human Rights Clinic presentation on our study of human rights in Georgia. I'm very pleased to welcome you to this event. I'm Stephen Schneebaum, Interim Director of the International Law Program at SAIS, a practitioner in residence, and it's been my pleasure this year to be the professor and guide and coach for this clinic presentation. Before you are 11 graduate students from the School of Advanced International Studies who have spent most of this year studying Georgia and preparing for the rollout of this report. Some of them now are in China, in Italy, all over the United States, and despite those difficulties, the students have put together, I hope you will agree, a quite impressive presentation, which they will make this morning and follow up with the publication of our report in full online and then eventually in hard copy. Before we begin our presentation, there are a number of people who have to be thanked, and it's my task to do that. The Human Rights Clinic is a hands-on learning experience. It was created here at SAIS some years ago by Professor Tiffany Basciano, and I hope she's here because she gets a lot of credit for what we've been able to do. And thank you, Tiffany. I hope you're listening. Each year, the clinic studies human rights in a particular country. This year, we selected Georgia for reasons that will be discussed at some length during the course of the presentation. And we have had extraordinary hospitality and interest on the part of our many friends in Georgia and many Georgian friends here in the United States. The number of people who need to be thanked include, first of all, SAIS itself, the School of Advanced International Studies, and in particular, the Dean of Academic Affairs, who has supported this project both academically and also financially, which has been a great help. Our administrator, our department administrator, Denise Melvin, who is with us, gets a big thank you from all of us. And the students who have assisted, who were not part of the program, but who have assisted in getting us to this point, particularly Akanksha Baidia and Kangdi Cheng. We also want to thank Shonda Hurt of the Energy Resources and Environment Program, who has been instrumental in putting this event together this morning. Here in the United States, we had tremendous support from the Georgian Embassy, and particularly from Sofia Gagachkori, who has been invaluable to us in making connections and teaching us about Georgia, and Ambassador David Bakaradze, who has been wonderful also in supporting us. In Georgia, we were privileged to meet with the United States then Chargé d'Affaires, now Deputy Chief of Mission, Elizabeth Rood. We met with Karl Hartzell, the Ambassador of the European Union to Georgia, with members of the Office of the Prime Minister, with ministers, deputy ministers, members of parliament, SAIS alumni in Georgia, NGOs of all descriptions, and we particularly call out Sector 3 for the hospitality that they showed us in Georgia. All of those people contributed to this project, and without them, we couldn't have done what we've done. So thank you. And we had the interesting experience when we were in Georgia. The people kept thanking us for our interest in the country. And in fact, now is our opportunity again to reiterate our thanks to them. The goals of this project are to not only to teach human rights, but to teach human rights in the context of the real world, in which those rights, with any luck, mean something, where rights are enforced and rights are implemented and rights actually affect the lives of real people. So we're focused not just on understanding the laws, but on understanding how they work, the principles that are actually carried out in Georgia. And of course, it was our purpose not to judge, that would be awfully presumptuous and pretentious, but simply to analyze and to report, to offer our thoughts for what they're worth. And that's what we're going to do this morning. The students will be the ones presenting today because this is their project and their report, and they put in an enormous amount of hard work. I will come back at the end to wrap up, but this is their show, and I hope that they are as impressive to you as they have been to me all year. The report itself will be available online soon. We'll have more details about that later. Hard copies of the report will be available sometime during the summer once the printing shops are back up and we can get all of the mechanics taken care of. Questions and answers are encouraged, or questions are encouraged. We hope to provide answers. And I suggest, please, that anyone with questions post them in the Q&A box, not the chat box. And at the end of the presentation, I hope we'll have time to deal with those questions and perhaps even to engage in a discussion. So can we have the opening slide, please? There we go. The title of our presentation is Rights in Progress: How Georgia is Implementing International Human Rights Law. Now, before we get to the substance of our presentation, of course, we have to explain how it is we went about this project, the rules of engagement, so to speak. And so to do that presentation, I hand the floor to Helia Peng, who will be speaking to us from China, and who is a member of the class and who will explain our research methodology. Helia?
Yes, I'm glad to present you with our research design in the first place. So a successful international human rights system actually relies not only on agreements to the treaties that buttress this system, but also their domestic implementation inside each and every country. And that is the premise of this report. And our goal is to understand whether and how international human rights norms are actually translated into domestic laws and how well they're enforced. So based on the year-long science course, the International Human Rights Clinic, this research involves 11 graduate students concentrating or minoring in international law and organizations, as well as the practitioner in residence in the science ILO program, Professor Schneebel. So why Georgia? Georgia is an excellent case to study, we believe. It has not been long since it became a full-fledged member in the international community, but it adopted key human rights instruments almost immediately after its independence, and the governments have been actively promoting legal development. We're so impressed by Georgia's strong desire to implement human rights norms. Therefore, we're saying Georgia should be a perfect context in which we can actually examine our research topics. So here we choose 3 specific areas to study, and they're police accountability, discrimination in the private sector, and freedom of the media. First, police accountability tests how well the state's law enforcement body can adhere to and also be held accountable for the human rights norms in their direct interaction with citizens. If police officers are not trained to protect human rights, or if they won't be held accountable for when they fail to do so, then human rights norms won't be practically meaningful. And legal treatment of discrimination in the private sector, on the other hand, reflects the extent to which private interests are regulated. That is to test what expectations and obligations a state has created, not only for its own organs, but also for sectors that act without government authority. And last, media freedom measures how well the members of a society can truly express themselves without intervention, censorship, or any form of coercion. So in each aspect, we utilize 3 lenses, on paper, in practice, and perception. First, we test human rights commitments made by Georgia in respective areas on paper. That is, whether legislation and institutional design are well aligned with international human rights standards, or whether there are potential deficiencies that may cause systematic issues. And second, we examine how well they actually function in practice by evaluating to what extent the system works and under what circumstances it fails to do so. And finally, we discuss how the three issues are perceived by citizens, civil society, as well as the international community, and what public attitude and phenomena these perceptions actually induce. So we hope these three aspects, as well as these three lenses, can compose a relatively comprehensive study of domestic human rights practice. So starting from the fall of 2019, we first studied the key international human rights instruments and institutions, and then we conducted basic research on Georgia. After dividing ourselves into three subgroups, we started to conduct background consultations with experts, and we established contacts for interviews in Georgia. And finally, in January 2020, our team visited Tbilisi for 1 week, and we conducted 32 interviews in total with government ministries, NGOs, members of parliament, international organizations, Embassy of the US, Mission of the EU, lawyers, media, and journalists. After coming back from Georgia, we continued our follow-up communications, and we did further desk research until this report finally took form. So it is worth noticing that this report is subjected to certain limitations. First, we focus only on the three aspects. Therefore, discussion may not apply to other aspects. And also, the occupied territory problem is beyond the scope of this project, although it's very important. Also, we only speak English during the whole process. So for all such reasons, we also spent only 1 week in Tbilisi, and we did not reach out to those claimed victims of these three human rights issues, which may also limit the depth of the report. And we don't take COVID-19 into consideration, as this research was conducted before the COVID-19. Overall, this report includes 3 parts: general background, 3 case studies, and our recommendations. Please remember, our intention is not to judge, but to report. So our team members will go on and introduce the whole report to you. Next section is the background introduction, and I'll pass over to Gabriela Science.
Thank you, Helia. Located in the Caucasus region of Eastern Europe, Georgia is bordered mainly by Russia, Turkey, Armenia, and Azerbaijan, as shown on the map. The country's capital, as well as its largest and most populated city, is Tbilisi, and the official currency is the Georgian lari. A diverse country, Georgia's demographic makeup mostly consists of Georgians, Azeris, and Armenians. The official language is Georgian, but other languages such as Azeri, Armenian, and Russian are spoken. The majority of the population is Orthodox Christian, and as one of the most respected institutions in the country, the church exercises an enormous influence in its cultural and political development. Today, Georgia is considered to be a small, low-income and transitional economy. Following the fall of the Soviet Union, the Georgian government has carried out significant reforms to strengthen economic performance, such as increasing trade integration with the European Union and China. Although not a part of the EU, Georgia desires to achieve membership and is working towards that goal. As a semi-presidential republic, the country's head of state is the president, who serves no more than 2 5-year terms, with the prime minister as head of government. Appointed by the president, the prime minister has executive power over domestic and foreign policy. Parliament is made up of 150 members, and currently the majority of the members of parliament belong to the Georgia Dream Party. The highest court in the country is the Supreme Court, and it consists of 28 judges who are appointed to lifelong terms by parliament. Now, I will pass it over to Britton, who will briefly discuss Georgia's political history.
Thank you, Gabby. Georgia has a long, rich history that cannot be covered in its entirety here. So we will begin at the start of the 20th century. At this time, Georgia was under the Russian Tsarist Empire, until achieving independence in 1918. The country was an independent democracy and passed a progressive constitution. But just 3 years later, Georgia was invaded by Soviet troops and became part of the Soviet Union for the following generations. Georgia was under Soviet rule for over 60 years until the fall of the USSR. Georgia voted for independence in 1991 and was briefly ruled by Ziad Gamsakhurdia. Following a brief period of turmoil and armed conflicts, Gamsakhurdia eventually fled the country, and Edward Shevardnadze was appointed head of the government. Shevardnadze, a Georgian politician, held the position of USSR foreign minister and served as a Soviet party leader. Calling upon old Soviet favors, he managed to rein in the violence with the support of Russia's military. Ultimately, Shevardnadze managed to lead Georgia to political stability. However, over time, Shevardnadze began to come under criticism for capturing the state rather than transforming it. Before long, the public became frustrated with unremitting, widespread corruption and self-dealing. As Georgia continued to try to pivot westward, the public was also not particularly pleased with the continuing reign of a Soviet-era leader. In the early 2000s, a new political figure was on the rise. Mikhail Saakashvili had emerged as a talented young politician. A Western-educated intellectual with liberal democratic ideals, he had served as justice minister within Shevardnadze's government. In 2001, Saakashvili founded the United National Movement, or UNM. 2 years later, in 2003, parliamentary elections were held. After the elections, which kept Shevardnadze in power, were exposed as corrupt, the public was motivated to action. Alongside other reformist groups, the UNM helped to galvanize public demonstrations that ultimately led to Shevardnadze's downfall. Massive crowds peacefully protested at the parliament building for 3 weeks, demanding Shevardnadze's resignation as president. Amazingly, Shevardnadze eventually stepped down, making way for new political leadership. The protesters carried roses, and the peaceful transfer of power came to be known as the Rose Revolution. In the subsequent parliamentary elections, the UNM emerged victorious by an overwhelming margin. After assuming power, Saakashvili initiated a host of sweeping pro-market and governance reforms aimed at uprooting corruption, revitalizing the economy, and continuing Georgia's focus westward towards liberal and progressive international allies. However, to carry out these major reforms and to achieve these economic gains, Saakashvili amassed great powers for the executive. While the concentration of power in the executive allowed for swift and comprehensive action, it ultimately led to public disillusionment with Saakashvili. A series of constitutional amendments adopted by Parliament in 2010 did somewhat curb the role of the executive. They were not enough to quell public fears surrounding the growing and deepening power of the president. In 2013, the opposition to Saakashvili's UNM consolidated under the newly formed Georgia Dream Party. The Georgia Dream ultimately unseated the UNM in 2013 when its candidate, Georgi Margvelashvili, won the presidency, defeating Saakashvili's bid for re-election. The transition in 2013 ushered in an era of change, along with the Georgia Dream Party. Its leader, the politically inexperienced billionaire Bidzina Ivanishvili, began to reverse the course of the country, a welcome change from Saakashvili's more authoritarian tendencies in later years. The Georgia Dream platform was built on the pro-Western, pro-European, and pro-NATO desires shared with the previous government, as well as increasing spending to aid the poor and introducing universal health care. However, different from his predecessor, Ivanishvili welcomed a reset with the relationship with Moscow. Widespread public satisfaction with Georgia Dream did not last long. Allegations of clientelism, cronyism, and kickback schemes for public contracts persisted. Election integrity remained a concern. Growing pressure from opposition political groups mounted and came to a climax on June 20th, 2019, when a Georgia Dream member of parliament invited a Russian legislator to address the parliament from the speaker's chair. This gesture immediately took on great symbolic importance for many Georgians who continued to protest Russian occupation in Abkhazia and South Ossetia. An estimated 10,000 demonstrators gathered outside the parliament in protest. As tensions within the demonstration escalated, the police fired rubber bullets into the crowd. In the end, over 200 people were injured. Following the protest, Georgian Dream has attempted to crack down on the opposition, including reneging on a promise to switch to a fully proportional electoral system and responding to calls for the interior minister to step down, by promoting him to prime minister. In November, demonstrators called for snap elections and the resignation of the current president, but to no avail. As tensions continue, the country looks towards the upcoming parliamentary elections in October 2020, which will be an important referendum on the direction of Georgia. I will now pass it over to Anna Marie, who will discuss two factors that will play a very large role in Georgia's future.
Thank you, Brittany. Georgia is at a crossroads. Historically, its Soviet legacy contrasts with its turn westward under Saakashvili. Geographically as well, Georgia resides at a crossroads between Russia to the east and Europe to the west. Lastly, Georgia is at an ideological crossroads between these two influences. The contrast of Georgia's relationship with Russia on one side and its relationship with the West on the other plays an important role in Georgia's human rights development. An obvious example of this divide is the 2008 Russo-Georgian War. Following independence, relations between Georgia and Russia were strained, particularly regarding the two autonomous regions of South Ossetia and Abkhazia. These strained relations had generated a series of ceasefires, a joint peacekeeping mission, and territorial arrangements during this post-independence time, but tensions came to a head in August of 2008. Contextually, what was going on? Just a few months prior to the August escalation, in April, Georgia's intention to join NATO was formalized at the Bucharest summit. This greater cooperation with the West was seen by Russia as a threat to peace, and in early August, South Ossetian separatists attacked Georgian villages, the Georgian army responded, and Russia intervened to support the separatists in a 5-day Russo-Georgian war. The war spread to Abkhazia, and in the aftermath of violence, Georgia lost effective control over both of these territories. Today, South Ossetia and Abkhazia, representing 20% of Georgian territory, still occupied by Russia and only recognized as independent by 4 other countries, including Syria, Venezuela, Nicaragua, and the tiny island of Nauru. In these 2 breakaway regions, the practice of borderization, or implementing arbitrary border fences restricting movements and dividing properties, is among many human rights violations in this territory, including rape, torture, kidnappings, and discrimination. Though this is a human rights report, these violations are beyond the scope of our research, given that Georgia does not have effective control over these regions. It is also important to note that Georgia has brought legal actions against Russia in the International Criminal Court, International Court of Justice, and European Court of Human Rights. Needless to say, relations with Russia are strained. In contrast to the antagonistic relationship with Russia is the aspirational relationship with the West. Quickly following independence, Georgia sought greater cooperation, joining the Council of Europe in 1999, and has served as a productive member for the past 20 years, today serving a 6-month term as president. Membership in the Council serves as a matter of prestige for Georgia, an avenue to harmonize its human rights norms, and a means to reclaim its European identity. Exemplifying this best is Georgia's aspiration to become a member of the European Union. The EU-Georgia Association Agreement was formalized in 2014 and entered into force in 2016. This agreement includes greater economic ties through a free trade area, social ties through a visa liberalization plan, and greater political cooperation, particularly in support for strengthening democracy, rule of law, and good governance. Membership in the EU retains high popularity, with 80% of Georgians supporting this pursuit. Regardless of how quickly or likely EU membership may be, Georgia's relationship with the West has nonetheless played an important role in Georgia's harmonization of human rights standards to the European model. Next, Sebastian will outline some of those standards in his discussion on international human rights law.
Thank you, and good morning to everyone in DC, and good afternoon to those in Georgia, and good evening to Helia in China. My section will cover international human rights law and how Georgia has adopted these norms. International human rights law has developed rapidly since the end of World War II. It's grown rapidly from a single aspirational declaration to a vast array of international and regional conventions, standards, and institutions. In order to understand the extent to which all of the reasons and why Georgia is incorporating human rights norms into its domestic legal system, I will briefly describe how this regime developed. The Universal Declaration of Human Rights, adopted by the General Assembly of the United Nations in 1948, was the first document to codify a global conception of human rights. Declaration of Human Rights gave rise to two internationally legally binding treaties, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. The ICCPR commits its parties to respect the civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, electoral rights, and rights to due process and a fair trial. The International Covenant on Economic, Social, and Cultural Rights commits its parties to work towards the granting of economic, social, and cultural rights to the non-self-governing and trust territories and individuals, including labor rights, and the right to health, the right to education, and the right to an adequate standard of living. Today, the covenants have 173 and 170 state parties respectively. Upon independence, the country quickly began to join the global international human rights law regime. On April 9th, 1991, the Supreme Council approved the Act of Restoration State Independence of Georgia in an emergency session. And this act declared that, among other things, the Republic of Georgia, striving for a dignified position in the world community of nations, recognizes and ensures equally all fundamental rights and freedoms of individuals, including national, ethnic, religious, and linguistic groups, envisaged by international law, as required by the Charter of the United Nations, the Universal Declaration of Human Rights, and the international pacts and conventions. Georgia was in fact then admitted to membership to the United Nations later, a year later in 1992. Georgia really cemented its commitment to international human rights norms with its constitution in 1995. And an important article, Article 4.2, declares that the state acknowledges and protects universally recognized human rights and freedoms as eternal and supreme human values. While exercising authority, the people and the state shall be bound by these rights and freedoms as directly applicable law. The Constitution shall not deny other universally recognized human rights and freedoms that are not explicitly referred to herein, but that are inherently derived from the principles of the Constitution. According to the Constitution, these universally recognized human rights and freedoms gain further prominence in two important ways. The first is that Article 4.5 states that the legislation of Georgia shall comply with the universally recognized principles and rules of international law. A treaty or international agreement of Georgia, unless it comes into conflict with the Constitution or the constitutional agreements of Georgia, shall take precedence over domestic normative acts. And so what this means is that the Constitution provides the international treaties, such as the ICCPR, as well as customary international law, including the contents of the Universal Declaration of Human Rights, a prominent position within the country's hierarchy of legal norms. This prominent position of international law has allowed domestic legislation to undergo changes to become compatible with those treaties. The Constitution also explicitly guarantees fundamental rights in Chapter 2. Articles 9 through 35 of the Constitution describe these rights. These closely align with the provisions of international human rights law and include the rights to equality, freedom of opinion, information, mass media, the internet, and others, including due process and procedural rights. Additionally, the Constitution establishes the Public Defender's Office as a body responsible for supervising human rights and protections. These provisions of the Georgian Constitution demonstrate the state's willingness to adhere to international norms and the human rights treaties that the state of Georgia has is a party to are listed in the slide. I'd like to draw some special attention to the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW, the Convention Against Torture of Other Cruel and Inhumane and Degrading Treatment or Punishment, and the International Convention of the Elimination of All Forms of Racial Discrimination, which are, of course, signed by Georgia. Overall, our research found that Georgia's constitution is in compliance with international norms. The country quickly adopted international human rights treaties and conventions during the years following its independence. This part right here concludes our introductory section of our presentation. And what I'll do now is I'll hand it off to Brent Alfred, Anna Marie Cruz, and Sam Davidoff Gore, who will begin the process of presenting the police section of our research. Thank you very much.
Thank you, Sebastian. Police accountability is a fundamental part of the international human rights regime. As agents of the state, members of law enforcement are tasked with ensuring that the rights of the citizenry are protected and maintained. Should the police violate those rights, the harm must be remediated. There is no specific international convention or treaty that governs police accountability. Instead, it's embedded throughout the entire regime. In our chapter, we discuss a number of international standards and best practices that arise from international law, norms, and guidance, global and regional levels. These standards are the metric by which we analyze Georgia's police accountability system. I want to highlight three in particular. The first is independence. Police accountability mechanisms must be independent both politically and from the institutions they hold accountable. This ensures that they operate free from interference and conflicts of interest, maintaining a fair process and building public credibility. The second is transparency. Police accountability mechanisms must be transparent in how they operate and why they make certain decisions. By publishing statistics and information and informing the government, civil society, and public about their activities, these entities can themselves be overseen. Finally, an effective police accountability system will be accessible to all who feel their rights have been violated. Both average citizens as well as members of law enforcement must be able to submit complaints, and these claims should be handled with sufficient sensitivity, especially when relating marginalized populations. Now I will turn it over to Britton, who will briefly discuss the history of police in Georgia.
Thank you, Sam. I will now provide a very broad, high-level overview of the history and evolution of Georgia's police forces since independence through to today. Immediately after Georgia gained independence in 1991, there was no formal functioning police force, and the country was ruled by roaming armed gangs and militias. When Edward Shevardnadze came to power in 1992, he was able to oust the militias and bring general stability to the country, eventually establishing a police force. This force, however, was notoriously corrupt, and patrol officers operated with complete impunity. The ranks of the police force were bloated in comparison with the country's relatively small size, and police were noted to have often shaken down, harassed, and abused average citizens. Over time, as the most visible representation of the corrupt state apparatus in daily life, the patrol police were almost universally disliked and feared by Georgians. In 2003, following the peaceful Rose Revolution, the newly elected president, Mikhail Saakashvili, inherited a state weakened by decades of endemic poverty and deeply rooted corruption. Upon taking office, Saakashvili immediately set about implementing a series of massive reforms in order to bring renewal to the country's police forces. Overnight, the entire 16,000-person strong police force of Georgia was fired, and new police were brought on board. The new officers were told that there would be a zero-tolerance policy on corruption, and if they failed to adhere to it, they were promptly fired. After 2 rounds of firing and rehiring, as well as a drastic reduction in the bloated rank numbers, police officers finally began to behave appropriately. Saakashvili also launched a public relations campaign to cast police officers in a more favorable light. This campaign included outfitting police in new uniforms, placing them in new patrol cars, running public service ads depicting them as good citizens, and even remodeling police stations to feature glass walls and street-facing windows, signifying the reformed institution's new transparency. The police reforms were quick wins for the Saakashvili regime in reducing corruption, and they were astonishingly effective. The police reforms under Saakashvili were remarkably successful and received international praise. By 2011, nearing the end of Saakashvili's rule, the police had become the most trusted element of the state among the broader public, according to polls. In the 2012 elections, Saakashvili was ousted from power by a rising political party called Georgia Dream. Georgia Dream is the ruling party today and has been in power since 2012. Under Georgia Dream, the patrol police forces continued to be well regarded by Georgians and continued to serve as the exemplary model for law enforcement in the region. However, last year, the patrol police came under scrutiny for its use of excessive force during the protests on June 20, 2029, which we briefly discussed in our overall introduction. Mass demonstrations had gathered outside of Georgia's parliament after an inflammatory incident in which a visiting member of the Russian Duma delivered a speech in Russian while sitting in the chair reserved for the Speaker of the Georgian Parliament, a significant and meaningful seat. As images of a Russian politician sitting in one of the highest seats in Georgia's parliament circulated, people began to flock to the parliament building to protest. The images were symbolic of Russian interference into Georgian political affairs, a growing concern. The demonstrators threatened to enter the building, and some individuals within the demonstrations were allegedly becoming violent. In response, the Ministry of Internal Affairs ordered law enforcement to disperse the protesters with tear gas, water cannons, and rubber bullets. The force used by law enforcement officers resulted in 275 injuries, among them 187 civilians and 15 journalists. Law enforcement officers were also injured by some of the protesters. Of those injured, 28 required surgery, and 2 civilians lost their eyes due to the inflicted trauma. The June 2021 protests illustrate many of the issues currently facing police accountability in Georgia that we will discuss today. Questions of police competence, the apparent politicization of investigations, and the provision or withholding of the rights extended to victims of crimes. We will address these police accountability issues in more detail in our following presentation. I'll now hand it back over to Sam, who will provide an overview of how Georgia's laws on police accountability work on paper.
Thank you, Britton. We begin our analysis by examining how well the legislation and institutional framework that comprises Georgia's police accountability system aligns with the international standards and best practices we discussed at the beginning. On the slide, we have listed the 15 mechanisms that we studied, divided into 4 categories. The first, internal accountability, refers to the mechanisms within the police institution. In Georgia, that's the Ministry of Internal Affairs, or MIA. The second, governmental accountability, contains the government's overall system of checks and balances. This includes all 3 branches of government, executive, legislative, and judicial, as well as any independent bodies set up for human rights protection or police oversight. The third, non-governmental, are the entities and organizations outside of the government that help provide oversight. These include non-governmental and civil society organizations, media, and the international community. And finally, community accountability occurs at the grassroots level, with the public itself working with the police. The heart of Georgia's system are the Ministry of Internal Affairs General Inspection and Human Rights Monitoring Department, the State Inspector Service, or SIS, and the Prosecutor's Office of Georgia. The accountability system within the MIA meets international best practices and standards in its mandate and structure, with sufficient independence, jurisdiction, and investigatory powers, as well as sufficient reporting requirements. Turning now to the governmental mechanism, the SIS is a newly established independent police oversight body, operational since November 1st, 2019. It is tasked with investigating allegations of human rights violations and certain criminal activities against members of law enforcement. It is legally independent. However, it is reliant on the prosecutor's office for procedural guidance and resolution of jurisdictional disputes. We find that the SIS's mandate is too narrow. It should have jurisdiction over all alleged police crimes and should be retroactive so it can handle investigations from before November. The prosecutor's office is responsible for all criminal prosecutions in Georgia, including those against the police. Prosecutors maintain significant control over the investigative process, as they are able to closely direct investigations and make decisions about who is designated a victim, a status that comes with certain rights throughout the investigative and trial process. Coupled with its ability to determine whether an investigation falls within the SIS's mandate, it is imperative that the prosecutor's office is free from political influence. While its statute is designed so that it is independent, the possibility of political interference in the process of selecting the prosecutor general, overseeing investigations, or granting victim status cannot be ruled out. I now turn it back to Britton to discuss how things look in practice.
Thank you, Sam. As discussed in the preceding section, Georgia's mechanisms for ensuring police accountability are located throughout many governmental bodies, as well as in civil society. To examine Georgia's implementation of this system in practice, we have focused on the practice of the two primary political accountability institutions, which are the Ministry of Internal Affairs and the State Inspector Service, as well as the overarching issues of politicization and competence, which were raised repeatedly throughout our research. Overall, the accountability mechanisms within the internal government body are working relatively well. The Ministry of Internal Affairs General Inspector and the Human Rights Body reliably review cases and forward them onwards to the independent authority, the State Inspector Service. The State Inspector Service became functional in November 2019, less than 3 months prior to our research beginning in January. While it is too early to tell how well the State Inspector Service is performing its mandate, a few broad conclusions can be reached. Firstly, the creation of the State Inspector Service alone is a hallmark achievement that should be acknowledged and applauded. However, its establishment was very delayed. The process of establishing the State Inspector revealed a troubling lack of government support for an independent police oversight institution. Civil society had long been advocating for the establishment of an independent body for police oversight purposes that could investigate alleged human rights violations committed by the state. After civil society pressure and many international recommendations dating as far back as 2014, Parliament finally passed legislation for establishing the State Inspector's Office in July 2018. However, the actual operationalization of the office was also delayed. According to the statute, the State Inspector was to begin operations on January 1st, 2019. This date was subsequently pushed to July 1st and eventually to November 1st. The official explanation for the delay was a lack of financing. NGOs objected to the postponements, especially since the second came so soon after the June 2021 protests. They noted that the prosecutor had opened investigations into charges that would have been within the State Inspector's jurisdiction had the institution been operational at the time. These delays suggest a lack of sufficient government support for the State Inspector or an unwillingness to prioritize it. To demonstrate its commitment to the State Inspector, the government must ensure that the institution is sufficiently resourced to carry out its mandate. While these delays are concerning, they should not prejudice an objective evaluation of the State Inspector's work. They do, however, emphasize the high standard to which the State Inspector Office as a whole is being held and the lengths to which they must go to demonstrate their independence and impartiality to the public. In its first 2 months of operation, the State Inspector received 351 complaints, which resulted in an investigation into 68 criminal cases, as well as one additional case being referred by the General Prosecutor's Office. The State Inspector's first published report shows not only that the body's police accountability function is being used, but also that the body is taking seriously its responsibility to report data to the public. This shows the institution's commitment to transparency and should be continued. The State Inspector has good working relationships with other Georgian institutions, especially the public defender. But the status of the State Inspector's relationship with the prosecutor's office is less clear. While according to the State Inspector Service's 2019 annual report, the two institutions have cooperated well, filing a number of joint investigative claims, the central issue between the two institutes is in regard to their mandates. Determining whether or not a case falls into the jurisdiction of the State Inspector or of the prosecutor's office can be controversial in cases that are less clear-cut. In fact, certain cases have already occurred that have raised questions over which body should handle the case. As Sam discussed, the prosecutor's office ultimately makes the determination of whether or not a case falls under the State Inspector Service's mandate. Some critics within civil society believe that this process for resolving jurisdictional disputes between the State Inspector Service and the prosecutor's office creates a risk of politicization. They argue that because the prosecutor retains the ultimate authority, it can effectively serve as the gatekeeper for the State Inspector's access to sensitive cases alleging official misconduct. These civil society members suggest that a fully independent investigative authority is needed, operating entirely outside of the prosecutor's control, oversight, or influence. I will now turn to overall issues that exist outside of any particular body or institution. Overall, we identified two cross-cutting issues that affect Georgia's practice of ensuring police accountability. The first issue is general politicization of the processes that are meant to ensure accountability. The second issue is the overall competence of police forces and investigators in appropriately handling complex or sensitive cases. Turning first to politicization, this emerged repeatedly and consistently throughout conversations with civil society groups, members of parliament, and various government bodies such as the public defender. All actors and organizations whom we consulted agreed that police forces in Georgia have come a long way in the nearly 30 years since independence. They are now generally trusted by the public and even serve as the model for all neighboring countries in the Caucasus region. This reputation is supported by an exemplary domestic legal framework that largely aligns with international standards and is designed to ensure due process and accountability for officers who engage in misconduct. Nevertheless, even this legal framework is still vulnerable to politicization by powerful forces occupying key positions in government who may be able to manipulate application of the laws for political gain. One example of such politicization is the issue of victim status. People officially designated with victim status receive certain rights during criminal proceedings. They're entitled to be informed about the charges in their case, to provide testimony, to request and to receive protection for themselves and their families, etc. With this access, victims are able to raise concerns if they feel that prosecution is not working to obtain appropriate justice. Victim status became an issue following the June 2021 protests. An investigation led by the Prosecutor General's office into the protests rendered a controversial decision. Just 3 MIA officers were criminally charged, and only 7 civilians out of the over 200 injured were granted victim status. As just discussed, victim status is an essential step in guaranteeing their role in it to obtain justice. By contrast, 17 protesters were charged with crimes, and 67 of the 73 injured law enforcement agents were granted victim status. The disparities in who received victim status and the apparent favoring of awarding victim status to law enforcement agencies implies that the process is being politicized. The lack of victim status for civilian victims of the June 20th protests has been criticized by civil society and international observers alike. The second issue we identified is of overall competence of police forces and investigators in handling complex cases. This concern primarily refers to the investigators' technical abilities to thoroughly and satisfactorily assess accusations, as well as law enforcement's ability to tactfully handle sensitive issues and volatile situations. Many observers felt that the excessive use of force during the June 2021 protests was caused, in part, by lack of competence among police forces on how to deploy the weapons and on how to use less potentially harmful crowd control techniques. The ability to competently perform these central duties is critical to law enforcement's efficacy and reputation among the public. Overall, we find that in practice, Georgia's political accountability system works very well in most cases of alleged misconduct. However, the system struggles to deliver accountability when cases have potential political implications. I will now pass the presentation on to Anna Marie, who will discuss how police accountability is perceived by the public.
Without politicization. But how do Georgians view the police? As seen in the upper left-hand corner, this NDI public opinion poll from December 2019 shows that the police are one of the highest-rated institutions in Georgia, just behind the Army and the church. Police have consistently maintained this high trust since Saakashvili's reforms decades prior. And even following the June 20th protests, which were met with excessive force by the police, the population did not consider the police responsible, instead protesting the government's greater ties with Russia. As you can see in the bottom left corner, they're wearing eye patches symbolizing the 20% of occupied territory in Georgia. Civil society, similarly, has applauded Georgia's progress on police accountability, particularly praising the creation of the State Inspector Service and Human Rights Department under the Ministry of Internal Affairs. Civil society, though, remains critical of politicization. International perception of police accountability is particularly important for Georgia, given its EU aspirations and reliance on international support. Georgia has made steady progress in developing its institutions in line with European standards. Its police reforms have become a model for other post-Soviet countries, And international actors like the US and EU have been, though they have been critical of the June 20th violence and will watch the 2020 elections with great interest. In sum, the perception of the police in Georgia, with its high trust among Georgians and strong cooperation with civil society and the international community, demonstrates functioning police accountability mechanisms. On paper, protections are strong. In practice, it is effective, though not without challenges. In addressing those challenges, we offered the following recommendations. To the Ministry of Internal Affairs, continue to improve training to reduce human rights violations by police officers, particularly for those sensitive, marginalized communities. And you'll hear more about these in the following discussion. To the Parliament of Georgia, we recommend reinforcing the State Inspector Service's independence by reducing the prosecutor's involvement throughout the investigative process, expand the jurisdiction of the State Inspector Service, and provide sufficient resources so that they can expand its operations throughout the country. To the Prosecutor's Office of Georgia, provide greater transparency when victim status applications are granted or denied and when determinations are made. And to the State Inspector Service, continue to build capacity to conduct effective investigations, strengthen the institution, and raise public awareness. This concludes our discussion of police accountability in Georgia. We will now transition to our second area of investigation, discrimination in the private sector, and Lee will discuss sexual harassment.
Thank you, Anna. I'm glad to have the opportunity to present the discrimination part of our report. And our group are investigating employment discrimination on the basis of gender, sexual orientation, and against ethnic and religious minorities in the private sector. I will now start with the gender-based discrimination. And the first salient issue we find is the sexual harassment in workplace. Well, a survey conducted by UN Women shows that 20% of Georgian women have sexual harassment in their lives. To tackle this huge issue, actually huge progress has been made in Georgia's legislation as sexual harassment was clearly defined and finally recognized as a form of discrimination when both the anti-discrimination law and the labor code were amended last year. And in practice, the public defender has played a very important role in combating the sexual harassment. The public defender is mandated to receive applications from victims, schedule hearings, and submit their recommendations to both parties. However, it is not always easy for the public defender to assess the cases. First, few victims asked for help immediately after an incident, and many of them failed to recognize that they have suffered an actionable wrong. Second, some victims even destroyed the evidence to put the shameful experience behind them. Besides, in Georgia, private employers are not legally obliged to establish an internal complaint mechanism to protect employees from sexual harassment, which makes the employees more vulnerable. So our recommendation is to remove taboos and to raise public awareness. And we suggest that the public defender should keep launching campaigns and training courses, and the media can also contribute by disclosing the name of companies with bad records of harassment incidents. And Parliament should consider making it a legal obligation for private companies to establish the internal mechanism. And the NGOs can also help by informing companies of the best practice of the world's leading corporations. Now we turn to another two gender-based discrimination, which are the gender pay gap and violations of pregnancy guarantees and maternity leave. Well, still, on paper, the law is quite good as it grants women equal career opportunities and provide pregnancy guarantees and maternity leave in the private sector. However, since the past decade, Georgia's improvement in narrowing the gender pay gap has been minimal. The failure we think to reduce inequalities due to limited access to economic resources for women and categorization of male and female sector jobs. Besides, the
employers in private sector also has no legal obligation to compensate an employee for maternity leave. And compared with European standards, pregnant women in the private sector cannot get time off for antenatal medical examinations without loss of pay. So our recommendations to reduce the gender pay gap is that the labor code should explicitly include the equal pay principle, and a comprehensive and transparent data collection system should be established to help monitor the gender pay gap. And to deal with the pregnancy guarantees and maternity leave issue, our suggestion is that the private companies should be required by law to provide specific guarantees, such as time off to attend medical examinations without loss of pay, and to provide a minimum compensation of women's salary during maternity leave. And next, I will pass the presentation to our team member Zixue, who is going to talk about the LGBTQ rights issues in the workplace.
Well, discrimination based on sexual orientation and gender identity is prohibited by the anti-discrimination law in Georgia. The labor code and criminal code also listed sexual orientation in the protected grounds of discrimination. The criminal code also contains an article to apply to crimes that are motivated by discrimination or intolerance. The anti-discrimination law designed the public defender as an equality body to monitor and supervise the issues related to the discrimination against this group, especially its equality department. However, in practice, the LGBTQ+ people face difficulties to access their rights in workplace. Article 5.8 of the Labor Code provides that an employer shall not be liable to substantiate his or her decision on not recruiting an applicant. This means that an employer has the right to refuse an applicant without stating any reason. This article increases the difficulty for LGBTQ+ people to collect evidence about the discrimination in recruitment process. In the workplace, LGBTQ+ people are usually the target of the hate crimes, such as being physically attacked and hurt at work because of their sexual orientation. However, law enforcement agencies do not have specific instructions to distinguish such crimes from the general crimes, which makes the article related to hate crime rarely apply in practice. The slow process in reality reflects the low awareness and the lack of recognition of LGBTQ+ people's rights in society. The polling in 2019 by National Democratic Institute shows in the 18 to 35 age group, only 38% of respondents thought the rights of sexual minorities are important. The Orthodox Church plays a considerable role in this issue. In fact, Church has expressed their strong opposition against the LGBTQ+ community in various events, including organizing Family Day Parade to hinder the Pride Day activities and criticizing the Georgian movie containing gay romance. Considering the Church used to be the most trusted institution in Georgia, their severe resistance creates a negative social narrative to the LGBTQ+ community, both in and out of the workplace. In addition, Russia's information warfare in Georgia weaponizes the LGBTQ+ rights issues to fight against the Western influence. The narrative of equal rights means giving away Georgian identity, forms a toxic atmosphere in society and impedes the community to claim their rights. Considering all the above, we offer recommendations to 4 different parties to improve the situation. For the government of Georgia, it's important to conduct more awareness-raising campaigns and to work with NGOs to reduce the existing negative stereotypes of LGBTQ+ groups.
While protecting conservative groups' right of peaceful expression, the government should not tolerate the incitement of violence against LGBTQ+ people, regardless of its source. We suggest the Public Defender of Georgia to develop specific mechanisms for the processing of LGBTQ+ grievances to protect the identities of complainants in investigation process. The public defender should also hold education programs and information campaign in universities and companies to raise public awareness and recognition of the LGBTQ+ rights and educate the community as to how to protect and defend those rights. For the Ministry of Internal Affairs, it should be tasked with training law enforcement personnel to identify discriminatory behaviors and crimes. This should be made a priority, and it would be beneficial to empower individuals to protest and, if necessary, to seek legal aid against illegal activities targeting the LGBTQ+ community in Georgia. Finally, the Parliament should draft more detailed laws to address discrimination against LGBTQ+ persons. For example, there should be more specific criteria and detailed procedures to identify discriminatory behaviors focused on those individuals at work, particularly given the lack of reporting on these issues. Next, Alina will talk about the discrimination against ethnic and religious minorities in the following slide.
Although Georgian law aligns well with human rights international conventions in practice, there are gaps in implementation. Ethnic and religious minorities experience forms of discrimination both generally and in the workplace. Georgia has the following demographics. The largest minority groups are Azerbaijani and Armenians. There's also small Roma, Jewish, and Polish communities. The Roma ethnic group in particular experiences severe marginalization. As for religious groups, minority religions make up only about 14% of the citizens of Georgia. Of the total population, 83% self-identify as Eastern Orthodox Christian, 10% as Muslim, 3.9% Armenian Apostolic, and 0.5% Catholic, with small clusters of Jewish people. Minorities do not have adequate access to education in remote areas, and some do not achieve fluency in the Georgian language when it is not taught in schools. This limits their integration and increases their isolation from Georgian society. It also makes it difficult for them to get jobs. According to the OSCE report, Ethnic Minorities in Georgia, school textbooks include intolerant language towards minority groups. The Georgian NGO Tolerance and Diversity Institute works on this issue. Segregation, education, poverty, and lack of opportunity limit minorities' employment prospects. Further, in the workplace, reasonable accommodation is required in the labor code, but is limited to those with disabilities. Sometimes, though, accommodation is needed by religious minorities, and they may wear specific kinds of clothing, need to pray at certain times, or mark holidays on different days. However, the labor code does not require that these requirements be accommodated. TDI, the NGO I mentioned earlier, Tolerance and Diversity Institute, has brought several cases to court involving Muslim women who were asked to take off headscarves in the workplace. The reported cases were resolved through mediation. However, such challenges are infrequent and not often reported. A study at Tbilisi State University shows that about 13% of ethnic Georgians got a call back when sending in a resume in connection with a job application, but only about 6% of ethnic minorities did. Cases alleging workplace harassment based on religion are rare, however, because members of minority groups often do not feel empowered to come forward. We also noticed that though data on discrimination in the workplace is not well reported, there are frequent hate crimes, and we suspect that the fear that hate crimes cause is likely to affect minorities in many contexts, including in the workplace. According to OSCE, in 2018, 344 hate crimes were recorded by the police. The U.S. Department of State tracks hate crimes related to freedom of religion, including anti-Semitic attacks, beatings of Jehovah's Witnesses, and vandalism of a kingdom hall. Some cases, including alleged attacks by government officials against Jehovah's Witnesses, were considered inadmissible by the Supreme Court. Other cases were delayed in local courts. There are also some issues with property owned by minority communities, which affects their ability to gather, worship, and protest. For instance, Georgia's Orthodox Church has a dominant influence on the religious and cultural landscape, and this can feel suffocating to minority groups. A 2002 agreement between the government and the Orthodox Church ensures that the church has certain privileges. These include tax exemptions, ownership of certain assets, access to state property, and military exemptions. The state does not give equal privileges to other religious groups, and there are ongoing disputes between the Armenian Apostolic Church and the Orthodox Church concerning 57 properties. Further, the Public Defender's Office and Tolerance and Diversity Institute have alleged that building permits have been denied to religious communities for discriminatory reasons. In the region with the largest Muslim population, Ajara, a community in the town of Batami, was seeking to build a mosque, but the permit was not granted, and TDI filed suit and won when they showed that the churches had been granted building permits nearby. To conclude, there is vibrant religious diversity in Georgia, but it requires the promotion of greater tolerance and human rights protection. Hate crimes, as well as limitations on minority communities' ability to gather, worship, and protest, can generate systemic disempowerment. This has an effect both within and out of the workplace. Our recommendations include having more accommodation for cultural and religious practices, expanded engagement with minority communities, improved integration and equality, as well as the public defender does a scrupulous job of investigating discrimination cases and enjoys the credibility for its activities, so its awareness campaigns on these issues could be expanded further. Also, within the Ministry of Internal Affairs, the Human Rights Protection Department could issue guidelines, perhaps with help with the Labor Inspection Department as well, since they work on issues regarding labor, so that could help for workplace discrimination. Both of these departments could issue guidelines in their respective areas on preventing discrimination and inequality. So that's it for this section, and the next speaker will be Gabriela Sanz on media freedom.
Thank you, Elena. So as defined by the United Nations General Assembly, freedom of expression is the right to gather, transmit, and publish news anywhere and everywhere without fetters. As such, it is an essential factor in any serious effort to promote the peace and progress of the world. Since independence, Georgia has established an independent media landscape, even promoting freedom of thought, diversity of opinion, and pluralism. The Georgian government implemented legislation that would uphold the freedom and independence of the media. However, financial strains hindered these aspirations, while certain historical events demonstrated how fragile newly established practices can be. 12 years after the fall of the Soviet Union, major events led to the Rose Revolution, a new administration under Saakashvili, a legislative changes demonstrating a strong commitment to maintaining a free and diverse media. Despite promising beginnings, opposition media outlets were soon targeted. In 2007, a prominent opposition outlet, Imedi TV, was accused of an incitement to overthrow the government, leading to a police raid and closure of the station. As a result, protests against the attempt to restrict freedom of expression were ignited. As such, Georgia's history with media has prompted a research question. To what extent is the media landscape truly free and pluralistic in Georgia? As well as our areas of research, which include how is it supported, who supports media freedom, and what challenges impede media freedom and pluralism. On that note, Olivia will now present how media freedom is supported.
Thank you, Gabby. Since independence, Georgia has ratified several key international treaties that support freedom of expression and freedom of the media. The definition of freedom of expression under international law has evolved and expanded thanks to the adoption of international human rights treaties. In January 1946, the UN General Assembly adopted Resolution 59, recognizing freedom of information as a fundamental human right and the touchstone of all the freedom to which the United Nations is consecrated. 2 years later, the General Assembly adopted the Universal Declaration of Human Rights, the flagship human rights document that protects freedom of expression under Article 19. Georgia has ratified several of these treaties, including the International Covenant on Civil and Political Rights, the ICCPR, which assigns positive obligations to the state in providing an effective remedy to those whose freedom of expression has been violated. Additionally, the International Covenant on Economic, Social, and Cultural Rights, the ICESCR, and the International Convention on All Forms of Racial Discrimination further protect these rights. Georgia is also party to the regional instrument of the European Convention on Human Rights, the ECHR, which enshrines the freedom of expression in Article 10. The ECHR is overseen by the European Court of Human Rights, located in Strasbourg, France, where it can issue binding rulings for member states regarding freedom of expression. In the domestic law, Georgia's constitution was ratified in 1995 and is very clear about the freedom of expression. Article 17 of the Constitution explicitly states that freedom of opinion and expression of opinion shall be protected, that every person has the right to receive and impart information freely, and that mass media shall be free and censorship inadmissible. In 1999, the Law on Post and Telecommunications established the institutional regulatory body of the Georgia National Communications Commission, or the GNCC, whose mandate is to regulate technical, legal, and economic issues related to television and radio network operators, and to further protect the interests of consumers. In 2004, Georgia passed the law on public broadcasting, defining the rules of establishment of an independent regulatory authority in broadcasting sector and determining the terms and procedures for issuing licenses and reviewing complaints. It also established the Georgian Public Broadcaster, or GPB, which is the publicly funded news outlet. Also in 2004, Georgia passed a comprehensive law addressing freedom of speech and expression that provides protections for journalists accused of defamation, putting the onus on the outlet to respond and not the journalists themselves. The law on broadcasting has undergone several changes since 2004. In 2018, a draft amendment to the law was introduced by the GNCC, which would expand the mandate of the GNCC from a regulatory body to having the ability to review hate speech created by television and radio networks. This is an effort to harmonize the law with the requirements of the European Commission Directive on Audiovisual Media Services. However, it has been criticized by members of civil society who are concerned about the effects it may pose to freedom of expression when an institutional body has the right to conduct content regulation. I will now pass it back to Gabby to further discuss in practice.
Various key institutions have taken on the role of advocating a free and pluralistic media landscape, most of them falling under the categories of international actors, civil societies, regulatory bodies, and members of the media. In working towards this goal, these institutions have either financially sponsored media projects, published reports on the various challenges faced by the media, hosted roundtables with government representatives, media experts, law enforcement, and so on, or have developed platforms to review the factuality of content. Each institution tackles different challenges, including the problems of disinformation, polarization, safety of journalists, and financial transparency in regard to the media. We will go into further detail on the specifics of these challenges in our next section, but for now, we would just like to highlight certain initiatives. In the sphere of disinformation, the Media Development Foundation has taken the lead in combating propaganda and fake news. Transparency International has long studied corruption and ownership transparency attributable to polarization. The Georgian Young Lawyers Association has conducted significant research on the events of the June 20th protests, the excessive use of force by law enforcement on journalists, the violation on the rights of media professionals, including the right to freedom of expression and the right to conducting journalistic activities. Finally, the Georgian Democracy Initiative has brought cases before the Constitutional Court of Georgia on behalf of broadcasters. For instance, in 2019, GDI argued a case on inequitable tax policies implemented by the government against opposition stations. Aside from these institutions, to maintain a balanced media environment, regulatory bodies such as the Charter on Journalistic Ethics works to uphold standards on the right to freedom of speech and expression. The Charter was established by journalists and is the only independent media self-regulatory body in Georgia. And ensuring their commitment to truth and accuracy, the Charter can sanction members in response to complaints regarding their professional ethics. To further combat persistent challenges, the Charter circulates petitions to protest government policies towards the media, gaining signatories from member journalists and the outlets they work for, which include both private and public outlets. On that note, Olivia will start us off on the discussion of the challenges that media freedom and pluralism face.
Thank you, Gabby. In perception, we found that there are several challenges that impede media freedom and pluralism. Those are polarization, media literacy, or rather the effort to combat disinformation, and the financing of an independent media. We found the level of political polarization remarkable during this moment in Georgian history. Polarization in the media environment threatens the diversity that the Georgian Constitution and legislation seek to protect. Media pluralism is vital to maintaining the freedom of expression and freedom of thought. Television channels are clearly aligned with political interests, deliberately presenting news that support party platforms. Although not unique to Georgia, this type of polarization is especially concerning, given the web of political connections between television owners and political parties. The Rustavi II ownership case was seen by many Georgians as an attempt to neutralize a pro-opposition voice, while others a simple case of ownership in a company. Although legally resolved in the European Court of Human Rights in August of 2019, it has left many in civil society feeling that changes in the outlet's ownership were politically driven. Reports of cyber attacks into opposition outlets, as well as the Georgia Public Broadcaster, and recent legal investigations into affiliates of opposition outlets have been raised as concerns of perceived censorship of the opposition. This reflects a deepening polarization of the media landscape in Georgia and poses a threat to the plurality of voices in that media landscape.
Main challenges to media literacy have included Russian disinformation campaigns and government troll activity. Russia has and continues to exert extensive influence over media outlets in Georgia to spread anti-Western rhetoric, primarily in the areas of South Ossetia and Abkhazia, to promote homophobia and xenophobia, arguing that the West is meddling in the country's societal and decision-making process, for instance, by promoting same-sex marriage and assimilation with migrants. As pro-Western trends increase in Georgia, the Kremlin has sought to counter those trends by spreading negative messages, often through pro-Kremlin Georgian-speaking actors. In 2018, a total of 2,392 anti-Western comments were detected in 18 monitored media outlets, up by 21.6% from the previous year. However, the spread of fake news has not been limited to Russian interference. In 2018, 100 fake Facebook accounts were opened by trolls linked to the government. The accounts mainly promoted the spread of content supporting the Georgia Dream Party and discrediting civil society and anti-opposition outlets by publishing posts based on false facts. Since their discovery, troll profiles have been shut down. Finally, financing of the media has been a major contributor to polarization. Unlike leading news stations that receive financial support from patrons, many journalists and media outlets struggle to gather the necessary financing. In Georgia, there is no subscription culture, thus most outlets rely on donor support. To maintain neutrality, independent broadcasters who do not receive government subsidies must rely on advertising revenue or funding from TV company owners. To further entangle an already battled domain, in 2018, Parliament overrode the president's veto of a bill to direct more advertising to the Georgian public broadcaster, an already state-funded outlet. Political interference and current financing practices are threatening the livelihood of smaller independent opposition media. All mentioned cases have exacerbated the greatest problem the media in Georgia faces today, a highly polarized and politicized media landscape. In a poll conducted by the NDI in 2019, 49% of Georgians believe that the country is headed in the wrong direction, an increase from 38% in 2018. To close off, Olivia will provide some recommendations.
Thank you, Gabby. Overall, we feel the state of the Georgia media environment is strong, pluralist, and free, protected both by robust domestic legislation and international human rights law, and supported by a vibrant community of advocates in civil society and international organizations. However, in our research, we do conclude that both polarization and the threat of disinformation contribute to challenges that impede Georgia's success. We recommend for authorities to implement equitable tax and financial policies for all media outlets, that political leaders look into enforcing existing ownership laws. Despite existing laws, ownership is clearly aligned with political interests. Political leaders should stop attempts to develop strict legal frameworks that against freedom of speech regarding deemed disrespectful of religion. Stronger emphasis must be placed in collaborating with civil society to strengthen internal review mechanisms that exist in television and radio networks. Representatives of political parties should refrain from interfering in activities of the media with the aim of influencing editorial policy. We also recommend that civil society continue to work with journalists to develop best practices of balanced information and diverse opinions. We encourage civil society to maintain its research into the effects of political polarization. A particular emphasis must be placed on developing strong media literacy programs that strengthen people's ability to interpret the news in Georgia. Continue joint efforts with international organizations to broaden the scope and reach of media projects. We recommend to international donors as well as the international community to pay close attention to reports of interference in editorial policy, the use of the media for political purposes by the ruling and opposition parties must be part of aid conditionality. Media literacy efforts must be increased as part of an international donor effort. And with that, I hand it over to my colleague, Daphne Carletti, who will speak about conclusions, our overall conclusions of the report.
Thank you, Olivia. So with this report, we try to assess the status of international human rights law implementation in Georgia's domestic legislation. And here are our conclusions. In terms of police accountability, when Georgians feel that their rights have been violated by a police officer, they have numerous ways to claim their right to a remedy, and they can be sure that it is handled in a fair, transparent, and independent manner. However, if their allegation touches politics in any way, they no longer have that guarantee, hence confirming that the police accountability system is plagued by the same issues of polarization, grouping much of Georgia's governance systems. Relevant actors, such as the State Inspector Service, understand the steps that need to be taken to build public confidence and to ensure the independence of the police accountability system. But it is now up to the government to motivate these reforms and then to the public to hold the government accountable. With regard to discrimination, Georgia's domestic legislation broadly aligns with international human rights law. The anti-discrimination law in particular is inclusive, progressive, and very promising. There are still gaps in domestic legislation, though, mostly regarding the protection of the LGBTQ community rights. The primary issue, however, concerns implementation, where we observed shortcomings towards all categories, gender, LGBTQ people, and religious or ethnic minorities. We were also challenged by the lack of reported cases and data regarding discrimination in the private sector. Keeping all this into consideration, Georgian commitment towards reaching anti-discrimination European standards is remarkable, and it is likely that the benefits of the still quite recent anti-discrimination legislation will be visible in the near future. For its media environment, Georgia finds itself at a troubling juncture. Constitutional protection of freedom of expression, and among others, the 2004 Law on Freedom of Expression and the Public Broadcasting Law contributed to the country's alignment with international requirements. However, the media environment is being affected by the concentration of ownership in the hands of a few. Moreover, given the strong web of connections between political figures and media owners, television channels are not just a representation of the hyperpolarized environment of the country, but also outlets for political interests. There is concern that the recent draft amendment on the law on broadcasting could lead to a growing pressure on the freedom of expression, such as attempts to introduce strict regulatory frameworks to address speech offensive to the church. None of these proposals have yet been materialized, but they may demonstrate a willingness to take steps that would restrict the freedom of expression. Overall, these potential attacks to the freedom of expression exacerbate the lack of cooperation between civil society and government, and this suspicion undermines the chances for progress in guaranteeing the freedom of expression to which Georgians are entitled. In conclusion, since its independence, Georgia took very progressive steps, and its good faith towards harmonizing its domestic legislation with international human rights law is evidenced by institutions such as the Public Defender, which has increasingly been empowered over the years, or the establishment of a Human Rights Council within the Prime Minister's office. These are extremely forward-looking steps which must be acknowledged. However, there is still a long way to go, as Georgians are well aware. 2020 will be a crucial year in Georgia, since elections are scheduled to be held in October, and the future administration will play a significant role in determining Georgia's moves forward. Nevertheless, as the Human Rights and Gender Equality Advisor to the Prime Minister, Leila Akiashvili, told us in January when we visited Tbilisi, some things, such as human rights, should not depend on politics or on political affiliation. We urge the government of Georgia to ensure human rights are protected by eliminating the politicization of institutions. I'll now pass it over to Professor Stiebbaum for final remarks. Thank you.
Thank you, Daphne, and thanks to all of you. I hope that all of you listening to this performance are as impressed as I have been by the degree of commitment, the involvement, the effort, the time, the creativity that all of these students have put into this exercise. I'm very, very proud of them, and I hope that everyone listening is as well. Now we have time for some questions. Let me just make a couple of housekeeping announcements. One is that, as you now see on your screen, the report will be available at the website that's provided there. We anticipate that it will be posted at or by the end of this week. So please, if you're interested in this, go to that website, pull down the report, read it, disseminate it. It is, I think, an extremely valuable one, or at least we all hope that it is. Anyone interested in obtaining a copy of this, this event, which has been recorded, should also contact us at the email address that's provided on the screen. We will be glad to give you an indication as to where you can find the report. Now, we're hoping that there will be a robust question and answer session. I notice that there are some questions that have come in. Now is the time. And let me begin by reviewing a couple of the questions that we have received. One of them, the first one, comes from someone whom I called out in our introduction, but I gather she wasn't online yet to hear it. Tiffany Basciano, a professor who was the creator of the Human Rights Clinic at SAIS, and therefore someone to whom we all owe a debt of gratitude, asks the question, what is Georgia's relationship with the EU really all about? Is the prospective membership of Georgia in the European Union a carrot for improving human rights compliance? And if so, is it a carrot that will forever be out of reach? Or is Georgia's affiliation with the European Union really going to make a big difference in promoting and defending human rights in Georgia? Who wants to take the lead on that?
I can take that since I had discussed it in the introduction. It's also an excellent question. Thank you, Tiffany. And it's something that we had gone into Georgia in mind. During our week in Tbilisi, you see European Union flags all over at almost every government office or just on the streets or in personal homes. It symbolically does play a very large role in the human rights harmonization that Georgia has experienced. As we kind of discussed, it plays different roles in the police accountability and discrimination, but overall, and in all of our conversations, it is a very effective carrot in harmonizing these goals. The perspective of Georgia joining the EU is a little bit less certain. However, it is undeniable that Georgia recognizes that it is essential for it to progress, to adopt these norms, regardless of whether there is a reward at the end. That was a sentiment that we garnered in a lot of conversations, and it seemed to me that those human rights norms had been eternalized past just that carrot. It had become something that Georgians had also started to take pride in. But by all means, any of my colleagues, jump in.
Anyone else want to jump in on that subject? Okay.
I can just add something that we heard. Something that's interesting is that the EU can actually provide cover to certain actions that might otherwise be unpopular. If I recall correctly, I think the anti-discrimination law, for example, was a major lift for the government. And it helped that they could say, well, you know, this is something that is required for the European Union. This is something that's important for joining the Western community. And that gives them some political cover to pass potentially controversial laws. So it's both a carrot, but it's also a useful political tool for the government.
Very good. Thanks for that. We had a question from Konstantin Kopalyani, who is a newly minted LLM from Duke University Law School, and who's provided us with invaluable help both in understanding Georgian law and also making connections for us when we visited Tbilisi. So we're happy to address this question. Konstantin asks about the question of discrimination in employment recruitment. And he asks whether we have any specific recommendations to ensure that that anti-discrimination law applies at the recruitment stage as well as after hiring. Someone in the discrimination team want to take that one? Someone on the discrimination team want to take that one?
Yeah, so for the loophole in the recruitment process, we recommend the Georgia Parliament to consider pass a law to establish a standard procedure so it can give the public defender or the court rights to request such information if someone complains such cases in front of the court, or they complain the cases in front of a public defender. So it doesn't need to fully change the labor code, but there should be a following procedure to close that loophole.
Okay. Thank you, Zeev. Thank you for that. We have a question concerning the role of the public defender. And all of the presenters indicated how significant the role of the public defender is. And the question asks specifically, should there be an expansion of the mandate of the public defender to address issues of religious and ethnic discrimination? Do we have any recommendations with respect to an expansion of the public defender's role in those cases?
I mean, they do address cases, like in particular, I mentioned the cases of like Muslim women wearing head coverings at work that had to be mediated. But I think that having more awareness campaigns on these issues and potentially even offering recommendations for companies to have some sort of like internal guidelines for reporting and for ensuring anti-discrimination within their company policies could be useful.
Okay, thanks for that, Elena. A question about gender discrimination. And the question has to do with the general sense of the labor participation rate for women in Georgia. Are women workers in Georgia concentrated in particular kinds of jobs? You mentioned the sort of sexual stereotypes that are in play in considering employment discrimination. Do those factors have any impact on the prospects for equality in the workplace?
I can take this question. I think that according to a report by UN Women of this year, so pretty recent, around 44% of women in Georgia are economically inactive, which is twice as much as men in Georgia. And I think that to answer your question, here in this specific context, the division between the private sector and public sector is particularly important, since in the public sector, access to even leadership position for women is much more accessible, whereas in the private sector, phenomena as the sticky floor are much more widespread. And so yes, it does affect gender equality in the workplace. It is an issue in the private sector specifically.
Thank you, Daphne. A question about LGBTQ issues. Do we have specific recommendations as to how the public defender could play a greater role in the promotion of LGBTQ equality and in combating discrimination against members of that community? See, do you want to take that one?
Yes. So in our recommendation part, we had 3 recommendations for the Public Defender of Georgia. So the first one is about designing a special mechanism for the processing of the LGBTQ plus grievance to protect the identity of the complainants, because one of their biggest concern is their identity will be exposed during the investigation process, which may create much more problems for their life, not only their work, but also their life after the investigation finished. So we think it will be very helpful if we can have such a special mechanism to protect their identity. And the second one is the public defender should hold education programs and information campaigns in the private sector, especially those companies, to raise awareness and recognize of the LGBTQ plus communities' rights in workplace. And the third one is, I think the public defender can also use those programs to educate LGBTQ plus communities about how they can protect their rights and defend their rights in the private sector specifically.
Thank you, Z. I'm leaving some silence here just in case anybody else wants to chime in. Here's a question from Professor McGraw, and frankly, I'm not sure I know the answer to this one. So if anyone does, please let us know. Professor McGraw asks, are there laws protecting whistleblowers in Georgia, both either in government or in the private sector? I'm not sure that's something we discussed specifically, but does anybody happen to have come across something like that?
Yeah, so I can take a stab at it from a police perspective, and then I think Daphne also had something to talk about. So we didn't look just particularly at whistleblower laws, but part of an effective police accountability mechanism is that other members of the Ministry of Internal Affairs should be able to raise complaints against police. So I think that is related to being able to be a whistleblower in that regard. And from what we can tell, the statute of the Ministry of Internal Affairs General Inspection Unit makes it very clear that other members of the MIA can and should raise complaints when they see violations. We didn't hear anything about any form of retaliation against those. So from that perspective, it does seem like there is sufficient protections and a sufficient culture of internal reporting, at least in the police sector.
I can add also from the sense of the freedom of law and expression, there is a stipulation around professional secrets. So information that's been divulged to doctors, lawyers, clergy, members of parliament, and journalists, among others. So that is protected under that law.
I think there is 2009 law on whistleblowers, but I think that's only applicable to civil servants. But I read this during my basic research before we went to Georgia, so yeah.
So we just had a wonderful question from one of our friends at Sector 3. Sector 3 is an NGO collective that that kindly hosted us for a number of events in Georgia. And we were asked, pick 3 words that you would use to describe the current state of Georgian democracy. 3 words, that's all you get. All right, so I'm going to call one person from each of the groups, and I'm going to embarrass you now. So Sebastian, what are your 3 words?
It's good to be the first one.
Yeah, sorry about that. Somebody had to be.
No, I'd say I'll pick young, stable, and developing. And the reason I think I picked those 3 words, it's because we have a democracy that obviously it's very young, maybe 3 decades. It's stable in that it's managed to consolidate its institutions. It's developed international or laws that are on par with international norms. And as we described in our first introductory section, it's been party to these international treaties now since its independence. But it's of course developing in nature, and a lot of what we describe in the report and a lot of the recommendations that we provide demonstrate that Georgia is ongoing and developing in a way. It's understanding of its democracy and how it needs to work to improve it. So I think those 3 words would probably best apply to what I perceived during the visit.
Great, thank you. Hillia, I'm going to embarrass you next. What are your 3 words?
Okay, I think I'll pick ongoing, challenging, and promising, because we all know that it's an ongoing process. And as we said before, Georgia, it has not been long since it acquired its independence, but we're impressed by how progressively it has proceeding in a process, and what result it have achieved. And so I would say it's very promising, but still it's very challenging as well.
Great, very well done. Liz, what do you think?
Yeah, I would choose 3 words progressive, ambitious, and I think also promising and exciting. Because as we during our conversation with the public defender, we can see that they have devoted great efforts in improving the legislation to combat discrimination, and I think they show their ambition to improving the human rights situation in Georgia, and we are expected to see what changes will be brought in the legislation in the following years.
Okay, thanks. Anybody have anything they want to add to that? I thought that was very well done.
I do. Just to note that the current, I mean, we talked about the desire for reforms to how Parliament is structured. That was one of the demands for the June 20th protests. And this is something that the government promised would happen and then said it wasn't going to happen until 2024. And currently, there's ongoing negotiations led by the EU and the US to compromise and basically make it so that there's fewer directly elected or fewer majoritarian seats and more proportional seats, which would hopefully bridge the divide between the government and the opposition. So I think there's a lot of uncertainty about the upcoming elections and what system will be used and how they will turn out. And all of that is compounded by the ongoing pandemic. And so I think uncertainty is also something that we unfortunately have to include.
And we have time, I think, for one more question. And the one more question that we haven't addressed is the big question. How do we feel about the future of human rights in Georgia? Are we confident? Are we optimistic? Are we concerned? Are we worried? Where do we stand on the big picture? The big picture, remember, the subject of this report has been rights in progress, the transition of international human rights law into the domestic laws of Georgia. And we've talked a lot about how it works on paper, how it's done in practice, and how it's seen by both the international community and communities within the country. But now that we are wrapping up, how do we feel about all this? I'm willing to call on people if nobody wants to volunteer.
I'll share one thought. That's a great question to sort of tie everything up. I would say hopeful. I think that Georgia's progress thus far has been astounding, especially in comparison to very much older democracies like the United States. Georgia is, I think, a paces ahead of the United States commitment to human rights. And I think the Georgian public, their engagement in government issues and their sort of resilience and always holding the government accountable, as we've seen in a number of peaceful protests and peaceful revolutions, will be a critical role in ensuring human rights are protected through the future and through the upcoming administration when it is elected.
Please, Gabby.
I just wanted to add that I agree with Britain. I think in the short amount of time that Georgia has been an independent country, they've gone a long way. They have ratified and they are members, they have signed a number of international treaties, legislation in the country as well addresses a number of various issues. And I think it's been very impressive the progress that they've put and how they continue to work towards achieving a full democracy. And I think it's hopeful as well. I think they're on the right track.
Anyone else?
I would also agree it's like very promising because it's happened like only 30 years since its independence, and now what we have seen is like very fruitful results. And I think the first step to resolve any kind of problem is always to identify problems. So on that, in that sense, I guess we're like Georgia is very clear about what problems they're facing. And so on that basis, they're able to like put very good legislation, and legislation I would say is overall very complete and well established. And so that makes us to focus on its practice. So, and I also observe that there is like willingness of the civil society to express themselves, as we can see their protests. And they're willing to make changes, and that's most important thing.
You know, one thing that nobody has mentioned, but that I think is worth mentioning, the vast majority of the people in government in Georgia whom we met, whose jobs involved the promotion and protection of human rights, were women. Not only women, but young women. And I think, at least, that is a vital point to be made here, that sexual equality across the board seems to be bubbling up through a system that, yes, has been patriarchal over the years. But the women lawyers and the women civil servants and the women diplomats that we met in Georgia were an enormously impressive body of people who, again, are in the vanguard of the very issues that we've been talking about. Anyway, I guess it's time for us to wrap up, and so let me do that. Again, by thanking all of those in attendance. We've had over 80 people following our presentation today. That's very gratifying to know. And we anticipate, we hope that quite a few of those have been in Georgia and have been listening to us. I had a very nice, in fact, two very nice emails just now from Ms. Elizabeth Rood, who, when we visited Tbilisi, was the chargé d'affaires at the American Embassy. She's the deputy chief of mission currently at the embassy now that we have an accredited ambassador in place. But Ms. Rood has thanked us, and through me, thank you for what she described as a valuable contribution. And I want to make that point again to be sure it's come through clearly. We had two goals in undertaking this project. One concerned the promotion and the teaching of human rights generally, that all too often the subject of human rights and the subject of human rights law is taught as an academic subject. It's taught as something that you can learn about from books, by reading international instruments, by studying the work of international institutions. And while obviously all of those things are important, what is far more important, as this class has discovered and explored, what is far more important is actually seeing how human rights work on the ground in the lives of real people. And the second objective, of course, was to speak to issues in Georgia. And some of what we've had to say, we hope will be of value to those whose task now is to guide the future of Georgia. And we hope that our recommendations, our observations will be helpful to them, because sometimes you need the views of outsiders to help you see yourself. And so perhaps the positions that we've expressed and the views that we've taken and the subjects that we've chosen to study may be of utility, and we hope they are, to Georgia. Now, I gather there's one more question that I didn't notice, and so let me raise that since we have another couple of minutes on our scheduled time, and then I will wrap up finally and end the presentation. The question has to do with the openness of the government and parliament, other governmental institutions, to input from the opposition, from civil society, and generally from the human rights community. Are we content with the degree of openness that we saw, or do we have recommendations to make in that regard?
I can try to maybe answer that question in that one of the main aspects that we mentioned throughout our report, and if it's not clearly outlined, it's implied, is that the country is going through a hyper-polarized environment where even though there is constant input from both the opposition and those in government, that hyper-polarization is really hurting the ability of people to maybe reach compromise or share substantive ideas on some of the most important issues that the country faces. And so although we were able to access the government, civil society, NGOs, and they were willing to share information with us, and we were very happy to meet with them, it was very evident throughout the meetings that what really separated those sides and separated their ideas and their constant commitment to what Georgia stands for is the constant polarization that the country is going through. So I would kind of pin my answer on that specific aspect of what I perceived and saw in the country.
Thanks for that. And I mean, after all, most of us are Americans. We know a little bit about hyperpolarized environments that don't permit compromise, right? I mean, unfortunately. Does anyone else want to comment on that question? openness of the Georgian governing institutions to input from those who may not be politically aligned with them, who have different kinds of points of view. Anyone? Okay, well, I suspect that we've actually provided our answer to that question throughout, and I hope that we've provided the answers to all of the questions that we received through the Q&A. Obviously, if people who are listening are going to read the report, which is, of course, far longer and far more detailed than what you heard this morning, we will be, all of us will be happy to engage in dialogue with anyone interested in communicating with us. We certainly have come away from this experience having learned an enormous amount about a fascinating country and a fascinating culture, fascinating history, and a fascinating future. And I think all of us, I love the question about the 3 words, because everyone who answered that question was forward-looking. Everyone talked about an optimistic attitude about Georgia. And certainly, one thing that we have all come away with is a deep sense of wishing Georgia well. Georgia has been on a wonderful glide path toward achievement of democracy against some very, very difficult obstacles. Not many countries have large chunks of their territory occupied by a foreign power, and yet that has not deterred the people of Georgia from taking the strides in the direction of realization of human rights that we've been talking about today. So we wish all of you who are listening from Georgia well, and we thank you again deeply for the hospitality, for the kindness that you've shown us, for the patience that you've shown with our learning process about Georgia. And we look forward to communicating further and to continuing the dialogue. And again, we wish all of you in Georgia well, and we thank all of you who've attended. And I thank most of all the 11 students in this class who have just done a phenomenal job in putting together this report and in this presentation this morning, in which they have summarized, I think, beautifully, a very lengthy and very detailed report. They've presented it in ways that are self-contained and that I hope all of you will have found to be useful. So thank you very much for attending. Thanks to my students, and all the best to all of you.